Good afternoon, ladies and gentlemen. My name is Michael Lawson. I am President and CEO of the Los Angeles Urban League. I want to thank you for attending this installment of our web financial series called Black Wealth Attainment and Retention Program. These Zoom workshops are brought to you through our collaboration with Parkside Economic Development Corporation. And I want to thank Gerald Smith for partnering with the Los Angeles Urban League in this effort to bring wealth and health information to our communities. This afternoon, we have two outstanding expert presenters who will lead the discussion aptly called, I Will, If You Trust Me. This webinar centers on wills, trust, caretaking, and caregiving. Dr. B.J. Hawkins and attorney Caprice Collins are well-known experts on these topics, which will help our audience retain and transfer wealth to their families. In a moment, these respected women will be introduced formally to you. Please enjoy tonight's program, and thank you for supporting our outreach to the community.
Good evening, everyone, and welcome to our fourth installment of the Black Wealth Attainment and Retention Program that we refer to as BWARP. Our topic this evening is, as Mr. Lawson said, I will if you trust me. I'm Reverend Gerald, and as a minister, I often find myself interacting with families at the most crucial of times, during and after the transition or a serious illness that incapacitates their loved one. I can't begin to tell you the emotional overload and drama and sometimes violence that ensues when the appropriate steps have not been taken to provide a legally binding detailed outline for the living care or the distribution of the deceased assets. At a time when family unity is paramount, differences of opinion and the interpretation of grandma's words or the assumption of what dad said he wanted turns grief into disdain and a third of that family's assets into tax revenue for the state. The size doesn't matter. I've witnessed families go to blows over costume jewelry earrings because they were mama's favorite. Tonight's session is designed to give us the insight and tools needed for a seamless transfer of wealth and ensure the proper and desired care when the time comes. I want to thank Michael Lawson, the CEO of Urban League, Brian Williams, COO, their board of directors and staff for supporting this program. And I want to thank the Parkside EDC board and all of our speakers for dedicating their time to BWARP. Most importantly, we appreciate all of you for sharing this evening with us, and we trust that you'll take away a nugget of information and inspiration to assist you in retaining the proper distribution of legacy wealth for your families. We all know the great legacy of the Urban League, and many of you know how Parkside gives away scholarships to young people and our financial literacy programs, which BWARP is an extension of. We're fortunate to have a great group of presenters who are the experts in their respective fields and longtime supporters. So we have covered many topics: Black wealth in a white economy, wellness and wealth that featured Dr. Zuri Morel and Dr. Gloria Moreau, a foundation built on home and business ownership that featured tax real estate expert David L. Murphy and retired banker extraordinaire and business strategist Daryl Brown. All previous presenters and bios can be viewed at laul.org/BWARP. And you can see all the previous presentations on the website as well. So before I introduce this evening's presenters, I want you to meet a wealth attainment and retention specialist that will be featured in our next webinar on October 13th. Joe Haywood, tell us a little bit about what we're going to hear on October 13th.
Good evening, everybody. My name is Joe Haywood, and I'm the president of Haywood Associates, and we're a financial planning firm. And I've been in business more than 35 years, helping clients achieve their accumulation and retirement goals. I, along with my colleague, Justin Lacey, I'll be presenting on financial planning and what that entails. Financial planning incorporates several areas of your life, such as cash management, which includes budget and crediting, estate planning, which you're going to hear about tonight from these wonderful presenters, risk management, which talks about insurances, accumulation goals, and retirement. We coordinate all these areas of your life so that you know what the left hand is doing versus what the right hand is doing. So for example, any budgeting decisions you make, how is that going to impact your retirement? How is it going to impact your accumulation goals? And my focus or emphasis will be on the accumulation and retirement goal pieces of your life. I'm going to help show you how to accumulate wealth, and I'm going to give you some practical understanding of investing. And I hope that these strategies will assist and help you, not only for yourself, but also your children's children, so that you can create a legacy of wealth building. Thank you, Gerald.
Thank you, Joe. Tonight's presenters are beautiful and powerful. They are both classy and intellectual, but their greatest asset is their desire to share their experience and knowledge to assist our community in the transfer of wealth and ensure fiduciary responsibilities are met. Our first presenter tonight is Caprice Collins. Attorney Caprice L. Collins is a top-rated Harvard Law School graduate. She has over 40 years of legal experience with a successful law practice devoted exclusively to estate and business planning and trust management. Attorney Collins is a well-respected keynote speaker on wills, living trust and estate planning, business planning, and trust administration. Welcome, Caprice Collins, to BWAR.
Good evening, everyone. Thank you so much for that wonderful introduction. I really appreciate the opportunity to participate in this wonderful program. And I just want to add a little bit to what Gerald had to say about me in my introduction that I think is really important. And that is, number one, that I am a homegrown girl. I'm a second generation Angelino. My family, my Collins family, has been in Southern California since the early 1900s. And I am a longtime resident of the overall South LA area, having gone to Audubon Junior High School, Dorsey High School, then on to UCI, and then eventually to Harvard Law School. So I've been in the neighborhood since birth, and I have a big affection for this community, a commitment to it, and I know its history. And so tonight, as I make my presentation, it is in part going to be because of the concern that I have about our community. In the 1960s, when African Americans were making significant progress in employment and in wealth attainment, we were able to acquire significant values in real estate in central parts of our area of Los Angeles, very valuable areas that basically were abandoned by other members of the community. And we took advantage of that and acquired those properties. But what we're seeing nowadays is there's been a change in that situation. And we have an opportunity right now for us to address that. I'm trying to advance my PowerPoint right now, and hopefully I'll get a little assistance with that. But while I'm waiting for that, then what I would like to do is also talk about the fact that I've been privileged to represent thousands of families here in the greater Los Angeles area in their preparation of their trust and also in the administration of their trust. And so I know from where I speak as relates to the ability for our community to actually make progress, plan, and the fact that unfortunately there are challenges that we face. Some of those challenges are going to actually be addressed by myself and also by our other speaker. And at this time, let's go on with Black wealth facts. So the facts are that we are behind, ladies and gentlemen. African Americans make up 12 to 13% of the national US population, but maintain only 2.6% of the national wealth. And I think we're all familiar about the many reasons why this is a fact, but there are opportunities for us to keep that and to add to it. In addition, we inherit 10 times less than Caucasians do in America. So we have to be conscious of those facts as we look forward to our ability to build a legacy. The US Census shows that 6.5% of Californians identify as Black or African Americans, but they account for nearly 40% of the state's homeless population. So this is a result, unfortunately, ladies and gentlemen, of not building wealth, of not making sure that it passes successfully from one generation to another. The number one reason why people fail to plan, and right now, 70% of Americans have failed to make any plan whatsoever as to what happens to them if they should become incapacitated or pass away. And that reason is this one, procrastination. Putting off until tomorrow what we know we need to be doing right now. So the other major reason is that people just don't know what they don't know. They heard about trust, maybe wills, also probate, and they're confused. They're confused about, well, what applies to me versus what might apply to others. But tonight I'm hoping to open a door of knowledge to you for you to understand what does apply to you and ways that you can use the opportunities to protect yourself and your family. Let's start off with an example of a happy married couple living here in Los Angeles, Bill and Mary. And Bill and Mary have a $900,000 estate. And that estate consists of the value of a single family residence, retirement funds that they've acquired over lifetime, bank accounts, and such. And they have a family, and they would like to see that family receive that value at the end of their lives. Their two children, Susan and John, very different in their personalities, but Bill and Mary want to make sure that they benefit from their hard work at the end of their lives. So as they go on, they have a things to do list, as many of us do. And those things to do including exercise, planning a vacation, increasing retirement savings, and create a will. But you see where create a will is in those lists, in that list? It's at the bottom of the list. So what do we call that when we take important things and not give it high priority? We talk about that and we call it procrastination. So Bill and Mary are basically procrastinating when, unfortunately, while walking around the park one day, Bill has a heart attack and is rushed to the emergency room. And at that time, Mary is asked for certain things that she doesn't have, like a power of attorney for healthcare decision-making that unfortunately they have never gotten around to making. As a result of that, Bill and Mary decided they're going to get serious about their planning, and they go to a real estate attorney to make a will. When they go to that attorney, the attorney really encourages them to go and make a full planning portfolio, including a trust, will, powers of attorney. But Bill and Mary decide that for now, a will be enough. After the heart attack, unfortunately, Bill has a stroke and becomes disabled. And at that point, he is really not able to understand business decisions, to participate in planning. Mary wants to do some things that would give better opportunities for care, like perhaps move out to an assisted living community. However, Bill doesn't really understand the logistics and can't consent. So what Mary is forced to do, and this is something that I want all of you married couples to be aware of, is just because you're married in the state of California does not give you the right to sign your spouse's name to legal documents. And in order for Mary to make that transition from their home to a upscale assisted living community, she needs Bill's signature on the deed to the property, on purchase documents for the new property. And unfortunately, Bill doesn't understand enough and really cannot consent to it. He's also lost in a stroke his ability to control the right side of his body. And as a result, Mary has to go to a court process called conservatorship. You're going to hear a little bit more about that with our speaker, Dr. B.J. Hawkins, in a few minutes. And I'm sure a lot of us have heard about this term recently because of the Britney Spears situation. But conservatorship is what we call an adult guardianship. So when someone has lost their ability to understand or to sign or to agree or to evaluate important things, then there is a court process, conservatorship, that allows the court to actually appoint a person that will be in charge of that. And this proceeding is primarily designed to protect those people who have become mentally disabled and unable to make their own decision. And so they appoint Mary. Mary is the conservator. Well, the reality of conservatorship, ladies and gentlemen, is that it's complicated and it's expensive. The average cost of attorney's fees in a conservatorship in Los Angeles has been estimated to be $25,000. It's humiliating because the person you love and want to protect has to be deemed to be unable to make decisions. It's time consuming, lots of court appearances, a lot of papers to be completed, aggravating because there will be constant reporting to the court before major decisions can be made. And private information that you might have preferred to keep within your family will be disclosed in a public process. After being in the conservatorship for a number of years, unfortunately, Bill makes his transition and there is required to be a death probate. And we're going to go into why that is the case, what other kinds of opportunities there are for planning as we go through what I refer to as the 5 myths. So myth number 1 is, if I have a will when I die, things will work out just fine. As we saw with Bill, unfortunately, that's not the case. When we have a will in the state of California, we are required to go to a probate. So wherever there's a will as the only document to control your planning, your family will be forced into the probate court. What happens in death probate? And let me just stop and say that death probate just doesn't happen when we have a will. Death probate happens when we have no planning at all. So when someone dies leaving anything in their own name, not something worth more than $150,000, not real estate, it can apply to a piece of jewelry. It can apply as relates to, let's say, a settlement that may be need to be authorized in a PI case that the person had successfully completed. Whatever is of value to that person could be forced into a probate. Why is probate necessary? Because it changes title to the asset. So if we have an asset only in our own name, then the court process actually changes the title of that asset, either pursuant to the terms of your will or by what we call an intestate succession, meaning by relationship you have to the person who passed away. There will be the appointment of an executor, and the executor is a person who's really in charge of making sure that this court process goes smoothly and completes. It is a forum to resolve disputes, ladies and gentlemen. Everyone in your family related to this person to a certain degree will have to be notified of this process and are free to come down to the court and participate. Payment of creditors, inventory of assets will be accomplished. And then at the end of the process, there will be a distribution of the estate, but it could be to possible undesirables. Who are they? They're people who you would not have wanted to receive anything from you, but because they were related to you, they got it. And charitable organizations that perhaps like the Urban League or like other worthy charitable groups will not receive anything from you because you did not make provisions for that in your planning. Besides it being one process that can bring in a lot of family drama, the disadvantages to probate are many. One is that it's expensive. Typically anywhere between 15 to 25% or more the value of assets can be lost in the process. It's time consuming. Typically the probate process will take in excess of a year. And in many cases, we've seen it go on for 5 to 10 years. It's public, meaning that all the information regarding the asset will be disclosed to the public, making a very heavy cost to the family. The other thing that I want you to understand is that, and we're not going to go into this in great detail tonight, but when someone has received Medi-Cal, which is not unusual, unfortunately, even in middle-class families, particularly as it relates to long-term care, those fees, those costs that Medi-Cal paid for will be paid back from the assets of a probate estate. Myth number 2 is my estate isn't big enough to worry about probate and estate taxes. Well, every one of us has something of value. And those of us who live in Los Angeles have even more than average. So the national average for the value of a home is only $180,000. Yet the average cost of a home or value in Los Angeles County is $700,000. It's almost 4 times the national average. If you just look at the rental costs in our communities, you can see how expensive it is. And California has some of the highest probate fees in all of the 50 states. What might be interesting to know is that here in Southern California, in Los Angeles, Central LA, we have the 3 richest Black communities in the United States. They are Baldwin Hills, View Park, and Ladera Heights. And what is a Black community? It means that, that primarily more than 50% of the residents are African American. We have other adjacent communities such as South Los Angeles, Inglewood, that are also close to the top of that scale, but unfortunately they are not considered Black communities. What we are being subjected to when there's a failure to plan are people who are very experienced real estate flippers who come into our communities, take advantage of families who are not organized and ready to really take control because they are been thrown in a probate, and they get the upper hand in terms of being able to cash out the real values of these properties by contributing funds to their improvement. I know many of us have seen that happen right in our own communities. And what is that leading to? It's leading to gentrification. It's leading to that our community is losing its political power. It's losing the value of the assets that they have worked hard for because of the fact that because these properties are so expensive, it can be very difficult for other members of our community, particularly young African-American families, to buy these properties. So the best way for us to prevent gentrification and to make sure that the legacy can be passed down from one generation to another is to prepare planning documents that will provide for that. Myth number 3 is a power of attorney will take care of all of my problems if I become disabled. Quite often I get a call from someone who maybe a spouse has had a stroke or is starting to show signs of dementia, and they'll ask whether or not, is that what I need, Ms. Collins, a power of attorney? Yes, powers of attorney are needed. However, they are only one spoke in the wheel as relates to protecting yourselves and your family. Powers of attorney that are documents that allow someone you choose to be able to actually manage and handle your financial affairs if you should become incapable of doing it yourself. Actually, a power of attorney can be used when you're fully competent and just want to delegate to another person. But most often they're used when someone has had some kind of disability. And what we find in many cases is that many major banks, insurance companies, and other financial institutions are very wary of honoring powers of attorney, particularly if those powers of attorney were prepared many years ago. And that's because of the fact that they can be used, unfortunately, to accomplish elder abuse and deprive people of their values, but more likely, the banks are just concerned about potential liability, that they will be sued if they honor the power of attorney. So really the best way to avoid conservatorship is to have a living trust. When we have a living trust, we are authorizing a person, whether it be a family member or a friend, that we've chosen to have control over our financial affairs. And when I say a living trust, I'm really talking about a full portfolio of documents, trust, will, powers of attorney, certificates of trust, things that will enable your value to be protected by it. This has a great effect in limiting elder abuse and preventing people within the family or outsiders from taking advantage of you or your family members. And unfortunately, ladies and gentlemen, right now, elder abuse is the fastest growing crime in the United States. There is also a special danger that all of us must be aware of. And we had a wonderful speaker a couple of months ago as relates to this, as to healthcare concerns in our community. And that we, unfortunately, in the African American community have a 300% increased risk for Alzheimer's disease of all forms of dementia than the majority community. Studies have shown that it's not genetic, but that it's really a result of lifestyle, a result of higher degrees of obesity, diabetes, high cholesterol, and other kinds of conditions that lead to this. So when we know that, then we need to give very, very special attention to making sure ourselves and our parents have adequately protected to prevent this particular disease from resulting in loss of a legacy. Myth number 4 is joint tenancy is the best way to hold title to my property. And again, I get calls from people who think, oh, Ms. Collins, if I put my house in joint tenancy, won't my spouse just get it at a time in the future, or my child? I'm just going to put my son's name on title in order to provide that he should get my home at a time in the future. Well, the truth is that if you're relying on joint tenancy as the way to preserve your estate, it is a costly and dangerous estate planning tool. Why is that? There's a lot of problems with joint tenancy with your child and others. When you are a joint tenant with another, you basically are owning the property equally with that person under the law. And I've had some people whose eyes get real big and they go, Ms. Collins, what do you mean equally? My son didn't buy this property with me. I'm the only one that bought it. Well, under the law, if you have a joint tenant, they are considered an equal owner of the property. And unfortunately, if they are an equal owner, then all of their family or life problems can actually attach to your property. So unfortunately, we've had instances where mothers have put children on their deeds to real estate, and then the child gets into tax problems, maybe has an accident where he's found to be negligent and there's a judgment against him, and our client's property ends up being levied on, meaning that the property is actually sold to pay off those claims. So understand that joint tenancy is not the way we give anything to anybody. What we are doing is we're putting our ownership and our security at risk by adding a joint tenant. The other thing is, even if you just as a spouse are sharing joint tenancy with your spouse, that you do not have the authority to sign on behalf of your spouse. So again, I'll have people call them and say, well, you know, me and my husband are joint tenants on our real estate, Ms. Collins, don't I have the right to sign his name to a new deed so that I can transfer the property so we can move out to Temecula and some, you know, better situation? No, you don't. If people, joint tenants, had the right to sign each other's names to deeds to real property, we'd have a lot of pre-divorce planning, ladies and gentlemen, where perhaps one spouse doesn't know that the other has in mind leaving the relationship, and they just sign off on their spouse's name on a deed and sell the property. No, both joint tenants must sign all documents related to that ownership. And not only must they sign, but they also have to be competent to understand what they're doing when they sign it. So as we saw with Bill and Mary after he had his stroke, not only was Bill no longer mentally capable of understanding what he was doing, but he had also suffered a disability of being paralyzed on one side of his body and was physically unable to do that. And that's where our spouse must become our conservator, as we saw in that factual pattern. And that's where our family will need to spend significant amounts of money at that time. And there is also, because this is a public process, opportunity for other family members to get involved in the business of perhaps two spouses. And often we see this risks show up when we have blended families and where maybe the children of the wife versus the children of the husband have different motivations and often come into court to cause problems. Myth number 5 is naming my child as a beneficiary on my life insurance or financial accounts is the best way to protect him or her. And the truth is that for many of us, we would not really be able to do that. Why? Because there are problems when we want to make a young, irresponsible, or disabled beneficiary the beneficiary of a life insurance policy or a bank account. For instance, minor children cannot have ownership of a bank account. Minor children would be necessary to actually have a guardian appointed. And then what if we have a family member who's disabled, a family member who maybe has autism or some other disability and is receiving, in many cases this involves adult family members receiving Medi-Cal, receiving SSI, SDI, other kinds of benefits. Well, those people will actually be liable to lose their benefits as a result of receiving something from you. And that's not the solution that my clients want. What's the solution to that is what we call a special needs trust. So there must be a better alternative than what we've gone through today. And that alternative is having a living trust. And living trusts work differently during different lifespans. When you make that trust, whether you do it as a married couple or single individual, you'll be in full control of your assets. If you had a disability or incapacity and needed someone else to manage, that person you chose would be authorized. And then at your death, those people you wanted to benefit, whether it's children, grandchildren, or others, would be able to do that. And so you can maintain control over time. You can decide whether or not you want to give incentives, perhaps college degrees are something you want to encourage. And you can protect your children from their divorces, from a divorcing spouse getting any access to their inheritance. Also, of course, if we have children who have medical needs or addictions, we can also protect them from themselves. So the advantages of a living trust is that we determine whom gets what we want them to have it, when they get it, and handled by the person you want. And this has to be one of the most important decisions that is made by an individual is, who do I want to handle things for me? Should I become incapacitated or pass on? Our wonderful professional fiduciary, Dr. B.J. Hawkins, is going to be talking about that in more detail in the next segment. And unfortunately, ladies and gentlemen, often close family members are not the right persons to choose. We may have to go to professional fiduciaries for the services we need. We also want to protect our families from Medi-Cal recovery. And this is the fact that when someone has received Medi-Cal, they will be required to pay it back at the end of their lives. A living trust completely avoids that. California has recovered over $1 billion in this process. Please be careful about where you seek your services. Please don't go online, don't use Zoom, don't use a paralegal or someone who's not a qualified attorney to assist your family. It will cost you dearly. Our firm, the Collins Law Group, we provide for our clients free phone calls, reviews, consultations, seminars, and we want to be there for your family, not only when you're well, but also at the conclusion. So please don't let this happen through confusion or procrastination. You lose out and they lose out. Your family is all depending on you to leave a legacy that will be shared not only with them, but hopefully with generations to come. My information here, where you can call us, 310-677-9787. Please feel free to do that. We have free webinars. You can call our office and schedule attendance at one of these webinars and get a free consultation with us. And I think our questions are going to be reserved actually to the end of both speakers. Is that correct?
That's correct.
Thank you so much for your attention this evening.
Thank you, Caprice, for that wonderful presentation and enlightening all of us that in order for us to do the right thing for ourselves and our families, we must have the proper legal documents here in Southern California. And each state is different, but this is one where without a trust, things can really get out of hand. And as Caprice mentioned, if you have any questions about what she had to say, you can submit them in the chat. And at the end of Dr. Hawkins' presentation, they will both be available along with other panelists to answer any questions you may have. So our next speaker is BJ Hawkins, PhD, Managing Principal of One Source Fiduciary Solutions, a California licensed professional fiduciary and trustee and court conservator. Dr. Hawkins is an expert in intergenerational transfer of wealth. BJ, as she is affectionately known, is dedicated her career to opening the door of financial opportunity to African Americans. She's a competitive tennis player, and BJ believes, like life, tennis is a head game that relies on endurance, skill, determination, and follow through. Please welcome Dr. BJ Hawkins.
It from beginning?
Yeah.
Good evening, everyone. I am happy to be able to follow my friend and someone I think has an enormous amount of expertise, Attorney Caprice Collins. I'm not going to spend a lot of time talking about a job description for a fiduciary. I'll simply state that a fiduciary is a person of trust. They handle finances, and as Attorney Collins has indicated, they handle personal and private affairs, which include healthcare. In 2007 in California, there was an act, the Fiduciaries Act, that basically allowed individuals that met certain criteria, having a good credit record and having no bankruptcies and no criminal record, to become fiduciaries. And for most of us, we end up being able to be appointed by the courts, the Superior Court section. I'm having problems advancing also. Jacinda, can you, for some reason, mine is not advancing either.
Okay, I'll share your presentation.
Okay, thank you. Okay, on the second screen, we're talking about the Britney Spears conservatorship in Black people. I think most of you have heard the Britney Spears story. It's been in the news, it's been on TV, certainly on Twitter, and there is a strong advocacy group talking about freeing Britney. Well, while we can talk about freeing Britney, we have to understand that conservatorships are actually a tool for Black folks, especially people from traditionally underserved communities. If we look at the backstory, we see that in this conservatorship, it's talking about actually two types of conservatorships. One, conservatorship of the estate, which handles all of the financial aspects, and one conservatorship of the person, which handles the healthcare, their recreational activities, whom they associate with, and basically anything that contributes to their benefit. That's important It's very important if you have an individual who needs assistance, a family member, for example, if we go to the next slide, who has been a victim of a catastrophic accident. What happens if they're in a coma and a brain injury? As Attorney Collins has indicated, that if a person can't sign on the dotted line, they cannot make decisions. You do not have their input. A licensed fiduciary can be a benefit. Unfortunately, in our community, there's just a handful of African-American fiduciaries. I was the first African-American fiduciary in the greater Los Angeles area in 2011. So for all of those years before, there was never a Black fiduciary. But now we have a Black fiduciary. We have at least a dozen or so in the state, and they can be helpful. They know where to go, how to get help, and so forth. It's not just if someone has an accident, it's also about parents who are losing their ability to be able to handle their affairs. What can you do when you see that a parent is insistent that they need no help and they do not wish to be treated as a child, but they shouldn't be driving? They can't handle paying their utilities and the money in their bank account is disappearing. Professional conservators, next slide, please, benefit Black families. They allow relatives to do more than bemoan or cry over the fact that a grandchild has become a permanent occupant in the house. And you know what? That same grandchild is driving a very expensive Porsche, and they say that their grandmother insisted that they have it. And at the same time, about $100,000 is gone from the pension account. This is when you want a conservator to come in. This is when you work with your attorney, you work with your physician, and you find a conservator, someone who is bonded, someone who is licensed, someone who has cultural competence, and someone who cares about Black families. I am certain that the grandparents did not think that their hard-earned work for 50 years was for the purpose of buying their grandchild the Porsche. We have situations where there are businesses or where people have rental income. The principal goes to glory and it ends up with relatives fighting each other, where the beneficiaries are screaming that one person took something out of the house and they're willing to fight to the bitter end, no matter what the cost. Well, the cost is, if there isn't a trust, as Attorney Collins has indicated, what do you do then? Well, one of the things that you can do is to get a neutral, so you don't spend all of your money hiring attorneys and paying court costs and paying for experts. What you end up doing is having a situation where you can have a neutral individual who is supervised by the courts to come in and make certain that everyone has an equitable share, that there is no one person that benefits over the other person. And they will also be able to find out if indeed that one person came in and either took money out of the account, or if someone took jewelry, clothing, furniture, all of those things. So even though we hear the Free Britney individuals talking about conservatorships are bad or trustees are bad, That is not necessarily true. And it certainly has never been necessarily true for Black folks in this community, because not only are houses on the line, but all of the hard work in obtaining assets. I want to speak a little bit about those of you who may be upper middle class, the talented 10th. I often hear about, well, all of their business is taken care of because they have excellent relationships with their banker, and they have an institutional trustee. I think that it's important to understand that banks indeed are trusted, banks indeed are regulated, but the person who is handling the family trust or handling handling what happens after a person dies may not be culturally competent. And the reality is that the trust business is not all of the time what the bank's strategic plan indicates that they need to emphasize. And what that means in practical terms is that banks are putting thresholds or minimum amounts of trust that they will administer. So most of the banks in California, in fact, in the country, do not want to handle a trust under $2 million in liquid assets. So that means the trust may be worth $2 million if you count the real estate, but banks don't necessarily count the real estate when they make the decision, even though they might have signed on the dotted line to be the institutional trustee, whether or not they will decline to serve or whether they will serve as the person to handle the business, the administration, and how the funds are dispensed in an equitable manner. So these are some of the things that I think is important for us as a community to understand, to know about. First is the trust, because as Attorney Collins has indicated, wills do not keep you out of probate court. In fact, they are a guarantee. And if I hear another individual tell me about how their parent or they know, or everyone knows how things are supposed to be divided, and there is no problem, I think I will explode. I was sitting with a group of women whom I attended college with, and I explained what it was I was doing because this is a second career. And it came out of some of the experiences that I have had in my own family. And one of my friends looked at me and said, well, I don't need a trust. And my mother doesn't need a trust because the only thing she has is a house. And she's already indicated that the house will come to me. I was so disturbed that here was this highly intelligent person who was ignoring the facts, the law, the reality, and they were going to tell me that they didn't need to know about a trust, they didn't need to know about an estate, they would never need a conservator or a trustee because everyone in the family knew who the house was supposed to go to. And they probably had a power of attorney, as Attorney Collins indicated, and that power of attorney would do nothing from keeping them out of probate. I want to talk a little bit about a California licensed professional fiduciary as a job or business opportunity. Most people don't understand that fiduciaries, private fiduciaries, I'm not talking about banks or insurance companies or institutional trustees, control over $100 million in California in assets. As a fiduciary, some of the individuals that I hire or contract with include physicians, because oftentimes I will ask for an opinions on a person's competency. So that includes also psychiatrists, psychologists. I routinely hire attorneys, either to represent me in court on court appointments, or a real estate attorney to look at a complex real estate matter. And sometimes I hire a litigation specialist in case I feel that litigation is appropriate on a case I've been appointed to. I hire property managers to manage properties. I hire landscapers. I hire real estate brokers, interior design. The point that I'm making that this is a growing business. As Alzheimer's grows, as our population grows older, as medicine is improved and people who have horrible accidents now can continue to live, these are all new jobs. And unfortunately, in our community, people don't know what a fiduciary is. They've never heard about a fiduciary. They do not know about the job opportunities. I hire fiduciary assistants. I hire fiduciary aides. And the last time I talked with a employment or human resources firm, they said, well, no one really had an interest because they didn't know. Well, if you have an interest, look up, just type in California fiduciaries or www.fiduciary.ca, and they will tell you about what's required, which does require, next slide, credit and criminal background checks, because you are a person that is trusted and handled. Next slide. I have a couple of facts that every African American should know. And these are facts for those who want to become wise, believe they are wise, or someone told them that they were wise, and those interested in retaining Black wealth. As Attorney Collins has indicated, a well-drafted trust is required to assure that your house, which for most families is their largest assets, benefit our future generations and not have to go through the probate process. But if you do, I'm excellent at probate cases, and I get my money because by law, when it goes through probate, you have to pay either an attorney or a fiduciary to go through the probate process. I think you've already heard about the rate of Alzheimer's, the 300% or 3 times. And the experts believe that obesity, hypertension, and diabetes in the Black community are the major contributors. And I don't think I need to say anything else about that. But I do say that we have to deal with reality. Sometimes it's not forgetfulness, and the person is never going to return to what they were before. One of the things that I had to do in my firm is to offer a one-time session for families to basically talk out alternatives and options, whether they needed to immediately go to an attorney or what type of decision-making they have to do before. And I did this because I felt strongly that in our community, we are not interested in having our business known by outsiders. But sometimes an outside neutral individual is the very best thing that can happen to the family. You don't have any of the family drama. You have a knowledgeable individual. So that's one of the things that my firm offers, for a modest fee, a one-time counseling session, or excuse me, a consulting session. Oftentimes it does turn into a counseling, but my expertise is as a consultant, so I will consult. Elder abuse is not only growing, next slide, but it is also a crime. And it's important to understand that it is a crime no matter who takes the money, who takes the valuables, or who takes the assets. I have seen situations where a child needs to make a payment on their credit card, and they will come in and they will convince the parent to add them to a bank account. And then they will take the money, not one time, but for over the years. Well, it adds up. And that is a crime. And many of us that deal with seniors feel that it is not prosecuted enough. The district attorney, I had a conversation with the assistant district attorney, and one of the things that was important to them is that this is prosecuted more. I've already talked about how it's important sometimes to bring in a neutral. The last thing that I want to talk about is couples living together. In this day and time, everyone lives together before they get married. Well, I can't say everybody, but the majority of individuals live together before they're married. And I want to especially direct this to those under 40, because they're more likely to be in a relationship where they are living with their significant other. One of the things that is extraordinarily important is to understand that if the individual gets involved in an accident and you have a friend or you have a friend relationship, the family can decide that all of the assets that you share are theirs, because they are next in line as the decision maker for the person who's in the accident. They can even keep you from visiting them in the hospital. And if you have a child, it's even more messy. So what I will say is that if you're talking about retaining Black wealth and being wise, you need to at least have a trust or some type of document before you decide that you're in love, but you don't want to just get married yet. Thank you for your time. I hope that I have been helpful. And I believe that Attorney Collins and I are now open to answering questions.
Hello, everyone. My name is Jacinda Moten, and I am the virtual producer of today's workshop. We will now begin the Q&A portion of the program. So if you have any questions, please put them in the chat, and I will address them one by one, and I will double spotlight Dr. BJ and Caprice. All righty. Let's see. Here's one question. My brother, sister, and I have always been close. Our parents taught us family first, and the family's business is not to be shared with outsiders. My sister has been helping my mother pay bills, and about $70,000 is missing from my mother's account. Who could help me?
Do you want to answer that first, Caprice, or do you want me to?
Go right ahead.
Okay, I'm going to plug in because my battery is going down. So let me just make a plug in, and then I'll be able to answer. And these types of situation, what my firm usually does is to have a consultation. And in that consultation, we review the facts and we try to establish a fact pattern to find out if indeed the individual took the money, whether the parent allowed the money. And based upon that, we may refer them to an attorney. We may ask for a temporary appointment so we can search both the bank account and to do an analysis to find out if there was self-enrichment or if there was some type of activity that could be classified as elder financial abuse. But what shouldn't happen is that the sibling tell the other sibling, you better stop it. And, I don't understand why you would do something like that, because the person will promise that they won't do it again. But in all likelihood, if you don't address it, they will definitely do it again, but the next time will be for more money.
Did you want to add anything, Caprice, or just move?
No, let's go to the next question. I think she did a great job.
What's the price range for establishing a trust?
Well, there really isn't any price range for establishing a trust. Just like anything else you can purchase things that are of different quality and get different prices. What I would just say is that you should try to use an attorney. Certainly don't use anyone or rely on anyone who's not as a non-attorney, but employ an attorney who this is the area they practice in and not PI attorney or someone else who is kind of doing you a favor. So go to an experienced attorney. And our firm particularly, we do have free webinars, and at those webinars, we do talk about the cost of our services. So if you're interested, please go to our website, www.collinslawgroup.com, register for a webinar, and you'll see the kinds of services you receive and the quality that you will get and the price that will be charged.
If I could just add to that, I refer to attorneys like Attorney Collins because they have the expertise and they have the knowledge. And you cannot expect to get a trust off of the internet, which may or may not apply to California law, and then be surprised when it's a mess and it circumvents the whole purpose of a trust. That's usually when someone like me has to come in and be a successor trustee, because the trust is so convoluted and so messed up that no one in their right mind, unless they were a bonded professional, would take over the role as trustee.
So the essence of it is you get what you pay for, just as we do in everything else in our lives.
All righty. Our next question is, I have a 96-year-old aunt and a 94-year-old mother. Is setting up a trust the first step? If not, what's first?
Well, I think the first step is to be involved with the lives of your family members, and that involvement can really eliminate a lot of unnecessary complications later. One of the things that really does protect our elders is by being involved with them. And so if you know that they need care, being taken to the doctor, perhaps having prescriptions filled, being helped with financial affairs, please do your best to assist them and be concerned and be helpful to them and be on the lookout for things that are, as Dr. Hawkins has pointed out, there are red flags like missing money from bank accounts and all of a sudden new assets that the person obviously could not afford on their own. But yes, now or never, if both of these ladies are capable of understanding what they could be doing as far as protecting their family, you need to get them to a licensed attorney like next week. You're very fortunate to have such long-lived relatives, and hopefully they will still be able to create legal documents. If they have moderate to late stage Alzheimer's, we would not be able to create a legal document for them, and it may be necessary for a conservator to do so. So please take advantage of good health of your elders and get them to a licensed professional immediately.
Thank you, thank you. And the next question is, my mom has a living trust and she has added my sister and my husband to her trust. I am married but separated from my husband. Will my husband have claim to my inheritance?
Well, your husband probably doesn't have a claim to your inheritance, but what you mean by added, I don't know. You know, the most important thing that we do when we make our trust is pick the right trustee. And that could be a position that you believe he's been added to. The other way you might believe he's been added to is as a beneficiary. The fact that your mother names him as a beneficiary or as a trustee of her trust will not be negated simply because you are separated or you divorce. There are certain areas of the probate code that do apply when someone has been divorced. That may mean that that divorced spouse doesn't receive something, but not in the case of someone just being appointed a trustee or a beneficiary in and of itself, unless the trust itself says that if that person is no longer married to my daughter or my son, they don't benefit, then yes, that would apply. But it would be curious to me why your mother would add your divorcing spouse or the spouse that you're separated from. That in and of itself is something that's, to me, a red flag.
All righty. Our next question is, what is the cost for a fiduciary, or is there an ongoing payment? If so, how is the cost determined?
I think that's an excellent question. Fiduciaries generally charge an hourly rate. The rate is dependent upon their skill and expertise. If they have a strong business background, if they can handle complex trust, or maybe a trust has an ongoing business, that's a different level than if it's something simple, or if it's a straight conservatorship because the person doesn't have complex assets. So I would say to you is that I think that about the minimum rate now is $125 an hour. It can go up to, if it's court appointed, up to about $250. And if it's private, it just depends. If you're talking about a $10 million trust, then no one is going to take it for a small amount hourly. That's different if we're talking about using a fiduciary in probate. There is what is known as statutory law, and Attorney Collins probably knows the rates better than I, but it's a percentage of the entire amount of the trust. Do you know what it is, Attorney Collins?
It's a range. It ranges on percentages. You know, a little complicated to talk about here right now. But you know, the reality is we want to avoid all that, and that's what we're here today to talk about. Is making choices when we have the ability to choose the ways in which we can preserve wealth, and we are not preserving wealth by going to probate court, by going to conservatorships. Obviously, having an experienced fiduciary like Dr. Hawkins in your corner, should that be your fate, is better than not having her. But what we really want today is for people to plan to preserve their wealth through generations.
Right, and I would add to that, the trust is important, period. Who manages the trust? If you've had a tradition of families fighting, sometimes it's less expensive to have a neutral than to have people fight each other and every decision that is made tooth and nail. But the most important thing is in our community is for them to get trust. And that is regardless of, and having a trust with a competent attorney. And that's regardless of fiduciaries, conservatorships, or trust, or trustees. The trust is what is important and a key element in preserving wealth.
All righty. Our next question is, they have an adult child with autism and then one adult child that is not on the spectrum. Do they need two different trusts?
Well, yes, you do if you're planning on benefiting both of them. In the case of the child that does not have any mental condition, they could be covered by a regular revocable living trust. All kinds of incentives and protections are in those documents, things like if that person were to start showing some signs of confusion or mental illness, then the trust, even in those cases, would allow the trustee to modify distributions to protect that person. But when we have a child like an autistic child that the condition is never going to change, we do need, if we want to benefit them through their lives, to develop a document called a special needs trust. A special needs trust doesn't stand on its own. A special needs trust is like an addition to a regular living trust. But what it does do is it basically protects that money from disqualifying our loved one from receiving benefits. So for instance, right now in the state of California, Medi-Cal is where most people who cannot afford, even middle-class people who cannot afford long-term care, end up going to get payment for long-term care expenses like in-home care, like nursing home care, like assisted living. And in the case of someone who's disabled, often they have been receiving some form of government benefit for a long time. And if not, after they become adults, then usually they start to be receiving that. In our state, you cannot have more than $2,000 of actual physical assets, meaning money in the bank, and qualify for Medi-Cal. So if we want a person who is already receiving those benefits or who more likely will receive them at some point in time to have full access to those benefits, which are very valuable. All of us pay taxes every year to provide them. No one should be ever ashamed of taking advantage of Medi-Cal or any other type of benefit. Then we don't want our child to be disqualified because we left them something. We want what we leave to be a supplement to their medical. A person, any of us sitting here tonight could be in a hospital for a week and come out with $1 million bill. And many of us are understanding through this COVID crisis, that's exactly what's happening to many families. People get advanced care in COVID and end up coming out of the hospital with millions of dollars of hospital bills. So we want our child to receive the full benefit of government benefits. We do not want them to be disqualified from whatever we might want to leave them. And we want to leave something supplementary so that they can have a little bit more than, $35 a month, which is what is allowed now in the state of California. Then a special needs trust will do all that. It will keep them from losing their benefits and allow them to allow you to supplement them after you're gone. So it would need a living trust to control primarily the estate, and then a special needs trust for that child who needs it.
All
Hey,
right.
Jacinda, can you hear me okay? This is Daryl Brown. My chat is not functioning at the level that I'd like, but I do have a couple of questions, if that's okay. First of all, to the two presenters, Dr. Hawkins and Attorney Collins, what tremendous information that you guys have provided. And Caprice, you make us Dorsey Dons very proud. So I just wanted to say that. But Caprice, you mentioned the role of the trustee, the executor, the conservator, but oftentimes the term administrator comes up. And if you could bring some focus to the distinction, the difference in how that role plays in the estate planning process, if you could do that. The second question, and that could be answered by either of you, and even maybe Joe Haywood, in terms of the role insurance plays in estate planning. I've often seen it to be very critical. Particularly when business is sold at 50 cents on the dollar in probate court. We know that key man, buy, sell, and insurance plays a role. And if you could just talk a little bit about insurance and the administrative role.
Okay, well, in the lexicon of estate planning, an administrator is really a probate term, and it means someone that has been appointed in a probate court to administer what we call an intestate estate. And unfortunately, if you would go down to probate court, ladies and gentlemen, and sit there for a couple of hours, you would think that African Americans own 80% of real estate in this LA County. Why? Because you will see 80% of the people coming in and out of the courtroom are African Americans. No, we don't own 80% of it, nor are we 80% of the population, but unfortunately we are often those who have to go to probate court because we fail to plan. And as Dr. Hawkins says, all these misconceptions that the family will know what to do and so forth, and leads us there. So an administrator is a person that's appointed by a probate court when there has been no will presented to the court. If there's a will presented to the court, the person is called an executor because that's what technically they are under the will. In the case of a person without a will, the court calls them an administrator. However, their tasks and their responsibilities are pretty much identical. The other way administrators are termed in this process is when someone actually is administering a trust after the death of the original, the maker of the trust. And that person can be also designated an administrator.
Right. I would just like to add on that. The other unfortunate thing, whether you go into probate court, is that oftentimes Black families don't pick appropriate representatives, or they are assigned a representative. There was one case where the family was going to have me designated as the trustee, the successor trustee. They got to fighting, they went to court, and there was another fiduciary who was in the court. Unfortunately, she was a known racist and barely tolerated people of color, and she was the one that got appointed. I was so sad and outraged, but I want to let my colleagues know on the call, I didn't sit silently. I addressed it, but unfortunately the family hadn't planned. They were so busy fighting that when they went to court, they had someone who did not have their own interests appointed.
All right.
And the insurance component, if someone could respond to just a little bit of the insurance, Attorney Collins, and how important that might be in the estate planning process.
Well, I would say that having money come to you at the end of someone's life is it can be a lifesaver. So when we're relatively young, even if we're in our 50s and we're young, I think having life insurance, whether we're just a average Joe or we are a business owner, can be essential in helping the family at the time of the death pay bills, be able to, yes, help with the succession planning, like for instance, help with the sale of a business, provide for, payments to others that need to be made at that time. Life insurance is very valuable. It's just one part, of course, that I know Joe is going to talk about at his next session of ways of building wealth. And I would definitely recommend it, particularly if we do have complex assets like businesses to protect at a time in the future.
Okay, thank you.
Okay, so for our next question, how does a reverse mortgage play out at death if someone does not have a trust?
Well, it plays out either way, whether you have a trust or not. It's a contract that's made directly with the bank by the property owner, which allows them to borrow on the value of their property, but not have to pay regular monthly payments on that loan while they are alive. They still must pay property taxes and insurance and maintain the property in a reasonable condition. At the end of their lives, the loan is due. And this is one of the things that I think is robbing our community, unfortunately. I see this in many cases that even our clients with trust have availed themselves of this, sometimes unwisely. I have seen people use reverse mortgage funds to buy expensive cars, go on vacation, not because they really needed it. If you are someone who really does need the access to your equity in your property, I think you should utilize this as well as you want, but I see it being utilized sometimes frivolously. So at the end of that person's life, the money, all the money on that mortgage is due and payable. These are products that are controlled by HUD, meaning they're standardized, which is a good thing because there can't be a one for the white community and one for the Black community. Reverse mortgages are all basically the same. Usually give somewhere between 6 months to a year for the family to repay that amount. And in all my years of experience, I have not seen one family that actually ended up retaining the property after a reverse mortgage was used. It always had to be sold in order to satisfy the reverse mortgage.
Attorney Collins and I generally agree, but on this one, we respectfully disagree, because I think that reverse mortgages will be the death of real estate in our community. Not only have I never run into a family that could repay, this, regardless of what Tom Selleck says, is something that can be extremely harmful. It's one of the most expensive and costly loans that there is. There's no doubt about it. This is something that the family should get together and make a decision about what are the alternatives. Do they want to pass the family? I have gotten calls from 20-somethings that said that their grandmother needed money for repairs, and because they wanted to update the house, so they got a reverse mortgage. And as I said, it is an extraordinarily expensive loan, and there were other alternatives, including family members deciding to help with the mortgage or to move in for a period of time because of the importance of creating Black wealth and retaining Black wealth. So my attitude is that there must be another way rather than a reverse mortgage. My colleague and my friend doesn't always believe that, but I just think that it's a loss to our community, the number of reverse mortgages that we see.
All righty. Our next question is, my mother's life ended. I had a court-approved conservatorship. However, now I'm told there is an additional court document required by Social Security. Also, I am receiving bills from a rehab center, even though she had a medical. Am I liable?
That question is too difficult to answer in this forum. And it depends upon the type of conservatorship, whether it was the conservatorship of the person or of the estate. I think that the person should seek counsel on it. They should seek a qualified attorney and get an opinion, or they can call the local bar association and find out if, because I do believe that on some areas that they have low cost, assistance if they can't afford it. But the best way would be to retain an attorney and to get a review and an opinion.
Yeah, generally, children are not responsible for their parents' debts, generally. But again, I think consulting with someone, as Dr. Hawkins has suggested, is a good thing to do.
Right.
So this will be our last question for the night, which is, can a life insurance policy be put into a trust?
Yes, a life insurance policy can be placed into a trust. The most common thing to do is simply name the trust as a pay on death beneficiary. And then I'm going to really, I appreciate this question, because this leads to one of the biggest mistakes people make, whether they make trust or not, and that is failing to fund the trust. Michael Jackson had a trust and he never funded it, meaning he never put anything in it. He never made it the owner of anything. And as a result, the trust was worthless. So how we fund trust are different as to what kind of assets we have. It's a house, we actually have to place the name of the trust on the title to the property. But in the case of a life insurance policy, most often we will simply just have the proceeds of the life insurance policy paid directly to the trust, meaning the trust is the beneficiary of the life insurance policy. And that is very, very important. It's very important that those in our family that our family members actually make everything come to this central area where it will be protected and managed by the person that we want. I have situations where the only thing in a trust is a house, and every other asset is going out to various people in the family. And when it comes time to manage the estate of the trust, there's no money to do it. There's no money to leave to the church that you wanted to get it. There's no money. Just this week, I had a case where if we had invested $30,000 in a piece of real estate here, we would have increased it by $150,000 in value. But because my client had left everything that I had recommended be placed through trust outside of trust, paid to a bunch of extraneous people, there was no way that we could even invest $30,000. So yes, having a life insurance policy being made payable to the trust where it will be protected, where it can be used for the benefit of paying bills, of making improvements, of satisfying specific gifts, very important that we fund our trust properly. There are other kinds of trusts that do actually are made specifically for life insurance policies called irrevocable life insurance trusts, but they are primarily used by people who have what we call taxable estates. And I think that's really a little bit more than we want to discuss today.
Yeah. Well, a taxable estate is what is it? I think 5 million.
No, the current exemption is 11.7 million per person.
All right. Okay. What I would say about that, I'm handling a situation now where the person used, I guess, the internet and did exactly what Attorney Collins said. And it is so convoluted because they named individuals on the insurance policy. They didn't name the trust. And it's even worse because it appears that one of the parties, when the senior was not competent, got them to change the beneficiary. So.
All righty. Well, that concludes the Q&A portion of the workshop. Thank you, ladies, for providing your insight and knowledge. Please, if you haven't already attendees, their contact information is in the chat. Dr. BJ Caprice, feel free to put your information again in the chat just in case if anyone missed it. And we will turn it over to Reverend Gerald.
I want to just take this time to thank everybody for spending their evening with BWARP. We look forward to your feedback. We want to continue to do these programs, and we need feedback from you to give us the insight we need to continue and make things even better than they are. So please tell your friends and family to register for our next workshop on October 13th and embrace the variety of ways that you can live well by strategic investing. Remember, you can gain access to our panel of experts at laul.org/BWARP or at parksideedc.org. We look forward to seeing you at our next event. We want you to be blessed and be safe, and please tell a friend about BWARP. Michael, you want to give us some closing remarks?
Thank you, Gerald. We trust you enjoyed this afternoon's Black Wealth Attainment and Retention Program presentation. Thank you for attending. And please, as Gerald said, please give our speakers, Dr. B.J. Hawkins and Attorney Caprice Collins, a round of applause. Thank you, Dr. Hawkins and Attorney Collins, for your expert presentations. I also want to thank Gerald Smith and Brian Williams, the Los Angeles Urban League's Chief Operating Officer, for your leadership in presenting these resourceful workshops to our communities. With hope, this afternoon's presentations will make you more comfortable about discussing wealth building with your families. We hope that you have learned something as a result of these workshops. Please reach out to the professionals on this panel or to the Los Angeles Urban League to learn more about wealth building. We've got your future on our minds, and we hope to provide you with the tools and insights that can help chart your way towards a robust wealth building mode of operation. As the Black community continues to face rampant discrimination based on race, gender, sexual orientation, and religion, we hope that you and this audience at these workshops will reimagine and energize the manner in which you think about wealth building and financial literacy. We can't think of a more worthwhile pursuit. Please visit our website as Gerald said, laul.org for more information on the upcoming webinar series and information on Los Angeles Urban League. Please be safe and good night.